Morning. We're now on YouTube, and the simple reason being we're not in the courthouse. And so we're on YouTube, and we're going to continue here with the July 20th, 2020 docket. And the next case here is CCD 0517D, Hidalgo County Water District number 3 versus Hidalgo County Irrigation District number 1. All right, gentlemen. What do we have, gentlemen?
Your Honor.
Go ahead.
Yes,
Danny.
sir, Mr. Growitz and Mr. Henderson. Yes, sir. What do we have, Mr. Growitz?
Your Honor, this is Danny Gerwitz and Meredith Helly and Allison Boyle appearing for Hidalgo County Irrigation District number 1. We are supposed to be here on a plea of the jurisdiction that Hidalgo County Irrigation District 1, our client, filed on June 1st. On Friday, Irrigation District 3, who's the condemnor or the plaintiff in the case, filed an extensive brief in response to our plea to the jurisdiction. And we need time to be able to prepare a response and an analysis of their brief. And so we have this morning filed a motion for continuance of today's hearing so that we can have time to do that analysis and brief it for the court. The reason it's particularly important in this case is because this is a plea to the jurisdiction. I think either side, the loser, is going to appeal this to the Court of Appeals because an interlocutory appeal will follow from this. And we want to make sure that on our side, we don't waive anything and that we have done a thorough analysis that is delivered at the Court of Appeals. A bit of background on the reason we're asking for a continuance. I spoke to Mr. Whittington last week and told him I did not want to continue the hearing. We were speaking about some issues unrelated to this hearing. But when we filed this on June 1st, the court originally set the matter for hearing on August, I believe, the 18th. And counsel for the condemnor contacted the court, indicated that they wanted the hearing moved up, and they were prepared to immediately proceed with the hearing. That, I think, occurred the week of July the 6th. I don't know when that week. The court then moved up the hearing date to July the 20th. And the brief in response to the plea of the jurisdiction was filed last Friday, so a business day before the hearing. So we think that to be fair to the court, so that the court can understand all these issues before it rules, that our client needs the opportunity to be able to respond to the issues raised in District 3's brief. We can explain the basics of the matter to the court today and come back for a hearing if that's what the court prefers. But we think it would be unfair both to the court and to our own client to have the court attempt to rule on this before our client, District 1, has the opportunity to respond to the brief that was filed by District 3 on Friday. Now, I don't believe there was a deadline for District 3 to file a brief, but because the issues involved, we need time to respond. Again, if this is filed on June 1st, they filed a response on July the 17th. We're not asking for 6 weeks to respond. I'll be gone most of the rest of this week and part of next week. We'd like probably 10 days to respond to the brief. And whether the court wants to reschedule a hearing for after we file a brief, or whether you want to hear from us today and delay ruling until you give us time to respond to the brief, we'll wait to hear from the court on that.
All right, Mr. Anderson?
I would start by saying that I think this motion for continuance is indicative of the strength of the plea that was filed in the first place. They filed the plea to the jurisdiction on June 1st, so they filed that plea roughly 2 months ago. It's their plea, not my plea. All I've done is simply responded to the allegations that they've made that this court doesn't have jurisdiction. I didn't have to respond to that at all. I could have simply shown up, joined this Zoom hearing today, and made the very arguments that I made to the court in writing. I will tell you that I filed that Friday. I didn't file it Friday at 5:30. I filed it Friday at 8:30 in the morning. Would have liked to have filed it potentially earlier than that. I will tell you that Mr. Whittington had reached out to counsel for District 1 earlier in the week last week to try to see if our clients couldn't come together to avoid this proceeding altogether. when District 1 told Mr. Whittington that they weren't willing to meet with us. That happened Thursday, I want to say somewhere Thursday around 5 o'clock. So we filed Friday at 8:30 in the morning. You know, to the extent that they argue they need to consider the arguments that I've raised in my response, my argument would be that they should have considered those arguments before they filed their plea to the jurisdiction. It's very possible that had they considered those arguments before they filed the plea, they wouldn't have filed the plea in the first place. It's clear to me, and I think should be again that this court has jurisdiction over this matter. And here's the other thing I'll say on it. My client is entitled to a writ of possession in this case. They're entitled to begin to start construction on this project. Typically, a condemnor doesn't really even go and seek a writ of possession from a court. Once they've had the commissioner's hearing, they deposit the funds and they're entitled to possess the property. They would simply begin go out and start building their project. And that's probably something this court's obviously familiar with. In this case, Mr. Gurwitz, on behalf of his client, sent a letter to the contractor working on this project and told the contractor that if they entered onto his client's property, basically they would be committing, I don't know, a Class A or Class B felony. So we thought it might be a good idea just to get a writ of possession so that the contractor would do the work for us. Any sort of continuance of this hearing today, Your Honor, is basically tantamount really to an injunction without Mr. Gurwitz having to prove any of the elements he would have to prove if he sought an injunction in this case. So what I would say is it's their motion, or it's their plea to the jurisdiction. It was filed over 2 months ago. And if they weren't ready to go on the plea to the jurisdiction, they shouldn't have filed it in the first.
I respond, Your Honor?
Yes, sir.
So should I respond to all the kind of non sequiturs, the stuff that's irrelevant to the motion for continuance, or should I just respond to the issues involving the motion for continuance, Your Honor?
Okay, for the motion for continuance.
So Mr. Anderson has acknowledged that he had the brief prepared at least before Mr. Whittington reached out to our client last week. I don't know why he filed it on Friday. And I acknowledged earlier that Mr. Anderson could have just come to the hearing. It doesn't mean we would not have asked the court for additional time to brief these issues. Mr. Anderson certainly probably will agree that the court needs to be able to analyze both sides before it enters its order. This is not tantamount to an injunction. We're only asking for time in order to be able to respond, because irrespective of which side wins, Mr. Anderson knows that this is going to go up on interlocutory appeal. And to be fair to the court, we don't want the court ruling before we have the ability to analyze Mr. Anderson's cases. I will say, Your Honor, it is incorrect that we believe that Mr. Anderson's briefing on this issue is correct. We believe we are entitled to prevail on the plea to the jurisdiction. We believe the court, no, we don't believe it is a matter of law that the court can decide whether it has subject matter jurisdiction.
Okay.
We believe that it does not.
Well, what if we have the hearing and I'll take it under advisement for the next 10 days to allow everybody to submit their briefs? Would that be an option?
We can, Your Honor, and if the court, again, we are limited in the response we can provide today, but we can argue it today, file our brief in 10 days, and then have the court
and rule in 10 days.
Either rule in 10 days or ask for another hearing if the court needs clarification on anything.
Yeah, I wasn't planning on ruling today anyway. I was going to rule sometime this week. But if you need time now for briefs, I'll wait 10 days.
Okay.
You know, Mr. Anderson?
Yeah, Your Honor, the only thing I would say to that is, you know, this project is ready. It's shovel ready. We are at the point where we need to cross District 1's canal. The project is at the point where that decision needs to be made, which is why we asked for this hearing to be moved up from the August date to as soon as we could have the hearing.
Okay.
You know, if they feel like they need to file briefing, I'm not going to tell them they shouldn't do that. I mean, my argument to them was they should have had that together. They should have had that together in the month and a half that's gone by since the time that they filed their plea to the jurisdiction. And if they do file a briefing, I would certainly think that I would be entitled to respond to whatever briefing that they filed, which is, you know, just frankly a recipe for further delay.
Well, can I would say now, give Mr. Gross, let's say 7 days, and then 3 days for you to do a reply. And that'll be a total of 10 days. So the court can issue a hearing, a decision. How does that sound?
You're the judge.
Your Honor, on our side, the 7 days is tight for us.
Okay,
Mr. Anderson is right. This was filed not 2 months ago. It was filed June 1st.
June
And
1st.
so they've had, again, 6 weeks to prepare their response. And I would like the 10 days. We may get it in 7, but I don't want to be,
Yeah.
I want to make sure this is briefed in full because it's going to go up on appeal either way.
Okay. All right, then we'll make it 10 days, which is what, today's what? Today's the 20th. That'll be what, the 30th? The 30th is what, a weekday? Weekday, it's a Friday, I think.
It's a Thursday, Your Honor.
Is it Thursday? Okay. Yeah, we'll rule by Thursday. Thursday afternoon.
So Your Honor, I want to be clear. Do we have 10 days to file our brief and the court's going to rule on the 30th? Or
I'll give you 10 days and I'll rule on Friday. The next day. All right?
Your Honor.
Yeah, let's do that.
Your Honor, if they file something in writing, I would certainly think I would be able to respond to that.
Okay. And how much time do you think you would need? 2 days, 3 days, Mr. Anderson?
Probably a couple of days.
Couple of days?
Not 10.
Well,
To
then Monday of the, what is it? The following Monday? Let's see, that would be August 3rd? Then it'll be August 3rd. But 10 days for Mr. Growitz. And then the rest of the period for Mr. Henderson's reply or response. Okay? Then August 3rd, I'll rule. That sounds better?
That's fine, Your Honor.
All right. It's a plea of the jurisdiction?
Plea the jurisdiction, yes, Your Honor.
All right. And what are you actually saying? That this court does not have jurisdiction? It should be a district court matter or what?
No, Your Honor. So I'll give you a bit of background.
Okay.
Irrigation District 1 supplies water to agricultural farmers in the area. It also supplies out of the canal we're talking about, I think 70% of the water, drinking water for the city of Edinburgh.
Okay.
There's a canal that runs east-west, just around Freddie Gonzalez, close to that area. Bicentennial Boulevard in McAllen is being paved north from Trenton to 107.
Mm-hmm.
And Bicentennial is going to cross this canal that goes east-west. And the city of McAllen is going to pave Bicentennial above the canal.
Okay.
At one point, a year or so ago, I don't know the exact date, in order for the road to pass over the canal had to go over underground. It was just an open ditch. And so through a contract with the city of McAllen, that canal, as it goes where Bicentennial is going to cross over the top of it, was placed underground in a concrete box called a siphon. So it's many feet underground and it runs east-west. And so you have the open ditch coming in from the west, then it goes underground in the siphon, then it comes back up on the east side of what will be Bicentennial.
Okay.
And District 3 filed its condemnation action in order to condemn an area that goes directly over or actually under the siphon. In that condemnation proceeding where the special commissioners, this court appointed special commissioners as it typically does, the special commissioners had the hearing. The only thing decided in a special commissioners hearing is the value of the land to be condemned, not whether or not the party has the right to condemn. We did not waive any argument about arguing that District 3 did not have the right to condemn by participating in the special commissioners hearing, which we did not do. And we filed an objection in this court, which the Supreme Court has said is appropriate. We filed objections in addition to, and our objections, Your Honor, were that the way District 3 wants to put in its infrastructure is going to substantially interfere with our operations and damage our infrastructure. That is, the way they have planned to put in their pipeline is going to interfere with both a canal that goes north for District 1, as well as that siphon. And if you damage the siphon, you are damaging delivery of water by District 1 to the city of Edinburgh and to any other customers of District 1. In addition to filing those objections, we also file a plea to the jurisdiction. The plea of the jurisdiction is based on several cases, one of which is a Supreme Court case. And in that Supreme Court case, this is cited in our plea to the jurisdiction. The court held that a water district can assert immunity from suit, even against a suit for condemnation on an easement by another governmental entity, which is exactly what we're doing here. In that case, they did not decide and specifically said, we do not decide whether you have immunity, but we do decide that you can assert immunity. And so that's what we're doing here. There are no reported cases involving water districts where the Supreme Court has said that a water district may not assert sovereign immunity in a case like this. Our position is, and I think the case that, one of the cases cited, I think by District 3 is that when you have two arms of the state, two irrigation districts, if they want to take land that belongs to us, that seems to be a matter of the legislature should take care of. There is nothing in the water code, and this court is aware, in order for the state or an arm of the state to be sued, there has to be a specific, unambiguous waiver of immunity from suit, immunity from prosecution, immunity of liability, whatever you want to call it. And in the response filed by District 3, they do not identify anything in the water code or any case where it has been found that a water district has waived immunity. They do cite to section 49 point, I think it's 222, Your Honor, of the water code. And they claim that 49.222 expressly waives sovereign immunity. And they claim that I'm looking at my notes here. They claim that it expressly waives sovereign immunity because it contains the word any. It says in there that, can you hear me, Your Honor?
Yes, I can.
Yeah. It says that in 49.222, and I keep referencing 222, Your Honor, because there's other codes that we say make it ambiguous. 49.222 says that a water district may condemn the property of any other, I think it says of any land. And so in this circumstance, they claim that because the word is any in there, it applies to both private lands, which District 3 condemns, and also public lands, which would be District 1's. But if you look at 49.218, also in the same water code, that references specifically condemnation, I think it's condemnation of, just a second. In 49.218, it says that a district may acquire either the fee simple title or an easement on all land, and it uses these words, both public and private, right? So if the legislature intended for District 3 to be able to condemn public lands, they could have written in 49.222 the words public and private, just like they did in 49.218. And so at the very least, there's ambiguity between 49.218 and 49.222. There are no cases interpreting it. And at that point, because it is not unambiguous, the court controlling its own jurisdiction should say, I don't have jurisdiction here because there has not been an unambiguous waiver of sovereign immunity, immunity from suit by District number 1. So that's really, Your Honor, we've got the Supreme Court case that we cite. There are no Supreme Court cases that say that have found that a water district unambiguously has waived sovereign immunity. And you think about this, Your Honor, if they were to condemn us, if the court had that jurisdiction, we could immediately file a suit for condemnation, getting the very same property back from them. And it's silly. If they want our property, they can handle it to the legislature. And we think that's how the code is written. In fact, there's one case, Your Honor, I don't think it's cited in what we filed so far. I think it will be in a response, where a similar thing happened to a water district in North Texas, in the Dallas area. In that case, one party asserted sovereign immunity. Subsequent to that, the legislature changed the law with respect to that district. And so because they had the law changed, in that case, the court sent it back to the trial court for reconsideration because the law had changed. So what happened in the case was one district said the other doesn't have, can't condemn us because of immunity. The legislature then changed the law, and then the parties had to go back to the trial court because the law had changed. So we think in this case, there has not been an unambiguous waiver of immunity, that the court should decline to exercise jurisdiction. And this should really be a matter for the legislature to consider.
All right, thank you, sir. Mr. Anderson?
Yes, thank you, Your Honor. Your Honor, I actually have prepared a PowerPoint presentation to share. I'm going to attempt to do that, to share my screen with you.
Sure.
Okay, it says host is disabled participant screen sharing. So I may need the host to turn that on. I don't know if you're the host.
Okay, let me see here. Can they help me here? You wanted me to do what again, Mr. Anderson? To
allow me to share my screen with you.
By
where does he need to go for that?
Okay, because I haven't done it yet. I haven't done this at all.
At the bottom of your screen, there should be something that says participants, chat, screen share, record, reaction. Do you see something like that?
Share screen right there. Right there, share screen.
And somewhere on there it should say allow participants to share screen.
We got participants here, but okay, allow here. One participant can share. There it is. Go back. Advanced sharing. Multiple participants can share simultaneously.
I think that'll work.
It's already one participant can share screen.
I've got one participant can share.
Okay, if you change it to where it says multiple, can you change it to where it says multiple participants can share?
Yes, I saw it there below. Let's see if we can.
That's done.
It's done already?
Okay, here we go.
Let's see.
That worked.
Okay, let me see.
That worked. So now I just need to pull up my PowerPoint, Your Honor.
Oh, okay. All right.
Okay, can you see my screen now?
Yes, I see it now.
Okay. So, Your Honor, let me start off by just kind of doing a brief recap, similar to what Mr. Garza said. This is a condemnation case. It's related to the extension of District 3's raw water line that's being constructed in conjunction with an expansion of Bicentennial Boulevard. The portion of our project basically runs from Auburn Avenue to just shy of 107. Just factually speaking, our project, I would say over 90% of our project is located in right-of-way that we acquired an easement for from the city of McAllen, a governmental entity. I would also point out that this very same easement crosses over District 2's water canal. When we reached out to District 2 to get permission to cross their canal, I think it took about 2 days for them to get us a permit to cross their canal. Irrigation District number 1 wouldn't agree to allow us to cross their canal, and now they're alleging we can't condemn the right to do so because that would be barred by governmental immunity. In essence, basically what they're saying is that one governmental unit can foreclose the public project of another governmental unit if those things intersect, basically by throwing down the King's X of immunity. I will tell you that we believe that defies reality. and is not the law in Texas. And it's basically for two reasons.
Okay.
First of all, we do not believe that governmental immunity is applicable in this case. We've cited in the response that we filed a series of cases. One is a recent case from the city of Conroe that talks about cases that are filed in rem versus cases that are filed in personam. And as this court knows, in rem is basically jurisdiction over a property and personam over the person. So I'll talk briefly about that. And then assuming that this court doesn't think the Supreme Court's recent ruling in city of Conroe is applicable, I'm also going to prove to you that immunity has been waived in this case. Here's what Irrigation District Number 1 has said in their pleading. A governmental entity cannot be sued unless the legislature has waived that entity's immunity from suit. Generally, a very true statement. But what I would say to you is that not all lawsuits are barred by governmental immunity. That comes from the Davey decision from the Supreme Court. And while the legislature is the governmental body that's responsible with waiving immunity if it's applicable, the judiciary is entrusted with defining when immunity applies in the first instance. And that comes right out of the Supreme Court's decision that was recently issued that we're about to talk about.
Okay.
Your Honor, in March of this year, the Supreme Court handed down a decision in the city of Conroe versus San Jacinto River Authority case. In that case, San Jacinto River Authority had entered into some contractual arrangements with a number of municipalities to provide them with water. And when they did that, they had to build the infrastructure. And as you know, when governmental entities build infrastructure, they issue bonds to finance those projects. So they issued some bonds, and the bonds were going along, and San Jacinto River Authority determined that they needed to increase the rates of those bonds. When they notified the municipalities of that, the municipality said, whoa, we're not going to pay those increased rates. So San Jacinto filed suit related to those bonds under the Expedited Declaratory Judgment Act. When they did so, it wasn't just the city of Conroe, but when they did so, multiple municipalities basically said, no, you can't do this. That suit would be barred by governmental immunity. And the Supreme Court in this case says, no, this is an in rem suit, and governmental immunity does not apply to an in rem suit. In doing so, they kind of took us all back to law school a little bit to talk about what an in rem proceeding was. And they said, really, it's an action directly against a thing or taking against a property as opposed to against the person. Your Honor, I would point out that multiple courts, and if you look in our filing, we set out more than just the city of Blue Mound. Multiple of courts have stated condemnation actions in Texas are also in rem proceedings. And when those courts have explained what a condemnation in rem proceeding is, they use the very same language that the Supreme Court used to describe the EDJA action that was pending in that case. So an in rem proceeding is an in rem proceeding is an in rem proceeding, whether it occurs in condemnation or in the Declaratory Judgment Act action, the Expedited Declaratory Judgment Act action that was pending in the city of Conroe. And in that case, Your Honor, the court talked about why the concept of immunity was not implicated in an in rem proceeding. And basically what they said is something that we all know, is that immunity really exists to protect governments from the bad actions of their governments and the money judgments that come with those. And what the Supreme Court said in city of Conroe was that the EDJA suit posed little risk to the public treasury, and there was no personal liability that would be implied or that would be inflicted on the government in that case. Same thing in a condemnation suit. We're not talking about the bad actions of a governmental entity. There is no negligence or no breach. It's simply a process to adjudicate the property interest. Irrigation District will never be subject to a money judgment in condemnation case. In fact, not only will they not be subject to a money judgment, they're going to get paid. for the right of way that's being acquired in this case. So, Your Honor, we believe because this is an action in rem, that governmental immunity does not apply at all. I assume this will be something that Mr. Gerwitz is going to want to go back and brief, 2 months after he filed his plea to the jurisdiction. But I would tell you that what they stated in their pleading is that the case that they rely on, Henry Lazy River, doesn't say that governmental immunity applies in a condemnation action. What Henry Lazy River said is they intimate no view on whether that entity was immune from suit. They had never done so, and that they need not do so today. And what I would tell you is that decision that they cited is from 2016. And I think that the City of Conroe decision, which came out 4 months ago, has essentially answered this question for the court.
Okay.
There is not immunity in an in rem proceeding. And so, Your Honor, that's their burden, okay? It's not my burden to show that governmental immunity applies in the first instance. That's their burden. They have to do that. Governmental immunity does not apply to an in rem action. And I believe that the court's analysis can stop here and that you could take jurisdiction, okay? So that's the first part. And again, Your Honor, I'm gonna try to say this in the least perturbed way as I can. That's the first part of my response to their argument that this is jurisdiction. Switching gears. If immunity is applicable, which we do not believe that it is, if it is, it's been waived. Like Mr. Gerwitz said, courts, when it comes to a waiver, it's the legislature's job to waive immunity. Courts have held that waiver must be in clear and unambiguous language, but the clear and unambiguous requirement is not an end in and to itself, Your Honor. That's certainly a method to guarantee that courts adhere to legislative intent. And we've cited in our response that, legislative intent is the pole star, of any sort of statutory interpretation. That's really what we're getting at here. Your Honor, what I would say is in the condemnation context, courts have found that there is a clear and unambiguous waiver when the law allows for eminent domain to be used to acquire public property. And that's not me saying that, that's the court saying that in State versus Montgomery. And what you see on the screen there is a direct quotation out of that decision. As Mr. Gerwitz hinted to, 49222 of the Water Code is where District 3 gains its power of eminent domain. It says that I have the ability to acquire by condemnation any land. We believe any land includes all land and includes the right to condemn public property. We set this out in some detail in our response, Your Honor, what the word any means when the drafters of legislation use that term. And what you see here is a citation directly out of Heim versus the City of Galveston. It basically says when construing statutes, the word any is equivalent to and has the force of every and all. That has also been examined, Your Honor, by courts in the condemnation context, where they've held that when the condemnation legislation used the word any real estate, that gave the right to condemn public and private land. And I want to walk the court through this analysis a little bit here because I think it's important. I'll try to do so as quickly as possible. This comes from the Houston 14th District opinion in Burlington Northern versus Santa Fe, Burlington Northern versus the City of Houston. In that case, a railroad was attempting and ultimately did condemn and ultimately did build a railroad over a piece of property that belonged to the City of Houston. The City of Houston raised a number of arguments in that case that they were immune from suit. Ultimately, this case, Your Honor, was decided on a preemption issue. It was decided that there was federal preemption at play. But part of the analysis that the court engaged in, I think, is pertinent to the analysis that you're going to have to engage in when you if you believe that immunity is applicable in this case, the analysis that you would engage in here. The court held what we've said here, their condemnation authority originally came from the Constitution, but the legislature had specifically authorized a rail corporation to condemn any real estate if it could not agree with the owner for purchase, and that included public lands. And when they issued that decision, Your Honor, they were looking at the three provisions that I've cited here from the revised civil statutes, 6316, 6317, and 6336.
Mm-hmm.
And I'm providing those with you because I want you to see how these match up with some of the provisions that are in the water code. Your Honor, as you see here, 6316 simply said a railroad can construct and operate its facilities between 2 points in the state. It said 6317 said railroads have right of way over public land. And 6336 basically said if they couldn't agree with the owner for the purchase of any real estate, then they could condemn it. Okay. Well, if you look at section 49211 of the water code, it gives water districts like District 3, frankly, like Irrigation District Number 1, the ability to construct its projects both inside and outside of the boundaries of the district. 49220 gives water districts the right to use existing public rights of ways. 49222 gives us the right to condemn any land. Your Honor, because the courts have that any land means both public and private land, and because we have the right to condemn public land, that constitutes an express and unambiguous waiver of immunity in accordance with the State versus Montgomery case that we've cited. I want to talk a little bit, Your Honor, about what Mr. Gerwitz said a second ago. The law, in a perfect sense, shouldn't be decided. It's not something that's considered and decided in a vacuum, right? It should have real world practical implications, and it should make sense in the real world. The reality is that when public entities like District 3 or like District 1 are going to build projects in inhabited areas with other governmental entities operating in those areas, they are necessarily going to come into contact with one another. There is not a way in reality for that to be avoided. You can read the slide that I'm giving you here on the screen, Your Honor. In essence, Nichols is basically the Prosser and Keaton of treaties on eminent domain. And basically what it says is when these things come to one another, they can be crossed. And if an agreement cannot be reached, they can be crossed via the use of eminent domain. One other thing to that point, Your Honor, when we are trying to construe statutes and figure out what they mean, we don't just look at the statute in and of itself. We look at the entire body of the law as it relates to that and try to make sure that those things work together and that they make sense together. The next section that comes after 49222, which is the section that gives my client the power of eminent domain, is 49223. And it talks about relocating property, the cost of relocating property. And as you can see there, what it says is, in the event that my client, in the exercise of the power of eminent domain, so we condemn somebody, and by doing so, we make necessary let's just say relocation, but basically the relocation or alteration of any road, bridge, highway, railroad, transmission line, telegraph, telephone property, facilities, or pipelines. If through the exercise of our power of eminent domain, we cause any of those things to be relocated, we have to pay for those relocation expenses. Your Honor, roads, bridges, highways, transmission lines, facilities, pipelines, those are all governmental facilities. Those are all types of governmental infrastructure. If we could not exercise the power of eminent domain with respect to those types of infrastructure, there would never be any reason for us to pay for the relocation of those types of infrastructure through the exercise of our power of eminent domain. Simply would not make sense. 49223 would not make sense if 49222 did not allow for entities like Water Improvement District Number 3 to condemn public property. What I would say in response to Mr. Gerwitz's argument about 49218 and its inclusion of the word public and private is that there are all sorts of instances where the words public and private are used. They're used in other sections of Chapter 49223. The legislature doesn't, because the word any, which has its ordinary meaning, includes both public and private, that they can say it that way. They can say it however they want to say it. Your Honor, in 49221, it also uses the words public and private. And there it's talking about the ability to survey. 49221A basically says I can survey any property in order to construct, in order to identify the best route of my project. 49222B says I can go on any public or private property to make sure that the water quality looks good. And then it goes on to enlist different responsibilities that I would have with respect to the property if it was public versus the property if it was private. And I would tell you, I wouldn't have the ability to go on public or private property under those statutes if I didn't have the ability to condemn it to build the project. Your Honor, that makes sense. And the reality is this idea of condemning back and forth is a fallacy. These projects, there's another principle. It's not at play in this plea to the jurisdiction, but because Mr. Gerwitz brought it up, I just want to address it. There's a concept that has existed in Texas jurisprudence for over 100 years. It's called the Paramount Public Use Test. And that process exists for instances like this instance, when one governmental entity wants to cross or acquire through the use of eminent domain the property of another governmental entity, and the condemning entity's project would materially interfere or practically destroy that existing use, they can't do it. And there's a paramount public use test that governs that. And what I would say to you is that test, frankly, would not exist in the world and would not have existed in the world for over 100 years in Texas. If all one governmental entity had to do to stop that was simply to say, well, no, you have immunity and you can never do it in the first place. That the existence of that test simply would not make sense if that were the case. So, Your Honor, just to recap, it's clear to me from the law. I think it'll be clear to you, regardless of what Mr. Gerwitz writes on the subject. First of all, that governmental immunity isn't applicable in this case because this is a proceeding in rem, and that even if it were applicable, that governmental immunity has been waived in this case. And with that, I'll turn it back over to you, Your Honor.
All right, thank you, sir. Mr. Gerwitz?
Yeah, I'd like to respond, Your Honor. I'll
Yes, sir.
try and be brief.
Sure. Mhm.
So in order for, can you hear me, Your Honor?
Yes, I can.
In order for immunity to be waived, it must be unambiguous. I think Mr. Anderson would agree with that. Ambiguous means capable of more than one interpretation. Unambiguous means capable of only one interpretation. Mr. Anderson has explained over the last 15 minutes how a series of statutes and cases, the cases unrelated to the water code, through that convoluted mishmash, you get to District 1 waiving its immunity in an unambiguous fashion. If it was unambiguous, Your Honor, it would not take this long to get there. It would be clear in the statute. It is not clear in the statute, so it is therefore ambiguous at the very least, which means that immunity has not been waived. And Mr. Anderson, I think, identified in 49.218 and in other parts of the water code where the legislature had the choice of using the words any or public and private, it used the words public and private in some and any in others. And on the part regarding condemnation, it did not use the words public. That's the first thing, Your Honor. Secondly, Your Honor, as to the cases he cites, Some involve cities, some involve railroads, some involve electric utilities. As Mr. Anderson knows, statutes for each of those are different in terms of whether immunity is waived. There are statutes where cities have waived, the legislature has waived immunity from suit for cities under certain circumstances. The same things may exist for railroads or public utilities. But so far, the legislature has not seen fit to put that language in legislation in the water code. And as Mr. Anderson agreed, I think, the Texas Supreme Court, when addressing the issue of the water code, has said, we have not yet addressed whether or not immunity from suit is available. They did hold in the one case we cited, the Lazy R case, Your Honor, they did hold that a water district can assert immunity from suit. That is, when given the opportunity to say, water district, you are not allowed to claim immunity from suit. When given that opportunity in 2016, the Supreme Court said, you are allowed to assert immunity. Whether or not it applies is an issue for another day. Mr. Anderson is now using a case involving a city, involving the Expedited Declaratory Judgments Act, that is not involving water code, not involving two co-equal state agencies, to bootstrap his argument that this is unambiguous. Again, when it takes you 20 minutes, involves cities, railroads, the public utility code, and various sections of the water code to try and explain to the court how something is unambiguous, I think that proves to the court that this is at the very least ambiguous. And to explain this project just a little bit more, Your Honor. So this siphon that goes underground, one of the allegations in the case is that what they're going to do is damage our siphon because they don't have the proper engineering, and they're going to damage it. We will be unable to supply water to the city of Edinburgh and other customers, right? That's the practical objection to why they shouldn't be allowed to do this. Not the legal objection, but the practical objection. Mr. Anderson talked about this paramount purpose test. We agree the paramount purpose test exists, but just because it exists involving other entities who have unambiguously waived immunity doesn't mean it applies here. But assuming it does, we believe that it doesn't because we believe the court doesn't have jurisdiction. If we got to the paramount purpose test, our argument is that what they're doing is going to damage us. And Mr. Anderson said, well, you know, we've got to pay to relocate your line if we need to. We're not asking for the line to be relocated, Your Honor. But if you ask Mr. Anderson, if you do damage his line, if you damage District 1's line, and they're unable to deliver to customers, and they suffer significant damages, does District 3 have immunity from suit and doesn't have to pay District 1 for the damages? I bet Mr. Anderson says, yeah, we don't have to pay you for your damages because we've got immunity from that type of suit. But District 1, you don't have immunity from our type of suit. So, Your Honor, it's a dangerous situation out there, both for the people who are going to be asked to put in the line and to the District 1 who may be damaged. If it takes you 15 or 20 minutes to explain through a variety of statutes and cases that something is really unambiguous, I think it proves the point that at the very least it's ambiguous, that the court should decline to exercise jurisdiction because the court has not waived immunity from suit. Because the legislature has not waived immunity for suit for District 1. We'd like the opportunity to more fully develop our analysis on these issues, but we ask the court to to grant the plea of the jurisdiction.
All right, briefly, Mr. Anderson.
Your Honor, am I on mute? Can you hear me?
Yeah, I can hear you.
Yeah, Your Honor. I mean, I would say it took 15 minutes because we did the work and we did the research, and we didn't file a one-page plea to the jurisdiction and then ask for relief after somebody responded to that plea with the law on the question. Yeah, the law is what the law is, and I need to walk you through what the law is in an effort to do so. I'm sorry if it took longer than Mr. Gurwitz liked. With respect to his arguments about paramount public use test, that issue is not before the court. But I'm just going to throw this out there. There are multiple other projects that already cross underneath this canal. The idea that public projects cannot cross other projects and could not And if one public entity said, you cannot cross me, if that was the end of that public project, that idea is so foreign to me and simply does not make sense. And what I would say in response to Mr. Gerwitz's argument about responsibility, I would say, yeah, 49223 says that I have to bear the cost of that. The other thing I would say, Your Honor, is 49220, which gives me section 49220, which gives me the right to cross public rights of way like their canal, also says that I'm on the hook for indemnity related to those crossings. The legislature's thought about this stuff. They've thought about public entities' ability to cross other public entities and the practicality that has to be the case. And they've provided for protection for that type of situation. Just one other example, when some of the roadway crossings were built across this canal, those did not, for example, when this siphon was put into place, the city of Edinburgh didn't go without water when the siphon was put in place. They simply engineered it so that the siphon can be constructed. This project will be engineered so that the canal is protected and so that no one goes without water. That's the practical reality of it. Your Honor, this court has jurisdiction over this case for the reasons that we stated. I guess I would just say we look forward to reading Mr. Gerwitz's brief and the opportunity to respond.
Okay. All right. Very good argument from both sides. Court will take judicial notice of the entire filing, cost number CCD 0517D in the case of Hidalgo County Water District number 3 versus Hidalgo County Irrigation District number 1. Court will go ahead and take this matter under advisement and will go ahead and issue a ruling. What did we say, August 3rd? August 3rd, to allow everybody to submit their briefs and any more responses. So gentlemen, good luck, and we'll get you a ruling by the 3rd.
Thank you, Your Honor.
All right, y'all may be excused. Thank you very much.
Thank you, Your Honor.
Thank you.